Okay, let's kick us off. Hey everyone, thank you for joining today's webinar, Protecting AI ML Innovations, IP Opportunities and Pitfalls. This webinar is sponsored by Amster, Rothstein, and Ebenstein LLP. Since 1953, Amster, Rothstein, and Ebenstein LLP have focused exclusively on representing clients in all facets of intellectual property law, both domestically and internationally. The firm partners with clients to protect and maximize their intellectual property in a broad spectrum of industries such as financial services, blockchain, artificial intelligence, fashion and retail, life sciences, medical devices, toys, entertainment, housewares, and consumer electronics. I'm Sean Edwards. I'll be introducing today's webinar. Before we start, there are a few housekeeping items to go over. If you have problems viewing the discussion or encounter any technical difficulties, please use your chat box to send a question directly to me, the host, and we'll try to help you. Second, I'd like to explain how we're handling questions. Due to the number of attendees, participant lines are muted. However, if you'd like to submit a question for our presenters, please do so using the Q&A feature at the bottom of the screen. We'll answer all questions that we have time to address during the program. Finally, please feel free to contact our presenters with any additional questions. Please note this webinar is being recorded. You'll receive an email with a link to the video so you can view it again. Today's program is structured to provide participants with 1 hour of continuing legal education credit in the category of professional practice. This credit is provided in accordance with procedures established under New York State's codes, rules, and regulations. Certificates verifying such credit will be emailed to participants by Amster, Rothstein, and Ebenstein LLP, the accredited provider of record for this program. There will be 4 codes presented at various intervals during the course of today's program. The participants will be required to record and report in order to evidence full participation. Participants will be able to present their record of the codes as part of the process for completing the program evaluation, which is also required in order to receive CLE credit. Please complete that evaluation by the end of the day tomorrow, Friday, June 19th. This activity shall also count towards continuing education for certified licensing professionals, that is 1 CLP CE credit. Now moving on to the next section of our presentation. The following presentation reflects the personal opinions of its authors and does not necessarily represent the views of their respective clients, partners, employers, or of World Congress. Additionally, the following content is presented solely for the purposes of discussion and illustration and does not comprise nor is not to be considered as legal advice. And I'd like to introduce our speakers now. Charles R. Macedo is a partner at Amster, Rothstein, and Ebenstein. Charlie practices in all areas of intellectual property law, including patent, trademark, and copyright law, with a special emphasis in computer implemented inventions. His expertise includes, among other things, artificial intelligence and machine learning inventions. Daniel Dardani, Technology Licensing Officer, is an intellectual property licensing professional at the MIT Technology Licensing Office, the country's premier technology transfer office. Daniel has over 17 years of experience at MIT managing a large and sophisticated portfolio of technologies, including computer and information technology, patented algorithms, copyrighted software, digital imaging, video games, machine learning AI, and cybersecurity technologies. And now, without further ado, I'd like to hand it over to Charlie to get us started.
Thank you, Sean. First of all, thank you to World Congress for hosting this webinar for us. And thank you to Dan Dardani for joining me in this presentation. In today's lecture, we're going to begin by discussing at a high level what is artificial intelligence and machine learning from the perspective of what you need to know on how to patent it. We're also, and protect it using IP. Then we're also going to have a section where we're going to discuss the current limits on IP protection for artificial intelligence and machine learning innovations. We'll also discuss strategies to protect such inventions and innovations in view of those limitations. And in the last section, Dan's going to explain various monetization strategies and perspective taken from his unique position at one of the premier innovators in this space, MIT. So we're going to begin with what is AI and machine learning. So when you think about artificial intelligence and machine learning, it really is the epitome of a black box. It has an input, which is the query or data set that is being fed to it, and it has an output of the result of what the machine learning algorithm will do for you. Inside the black box, there's 2 significant things. One is the machine learning algorithm, the software that says, how do I figure out the solution to this? And the other is the training set that's used by the machine learning algorithm to convert the query to the output. The training set is a very large part of what we're talking about with respect to machine learning. And here I represented the training set as sort of a giant Excel spreadsheet where you have, in this case, M different samples, each of them represented by a row. And for each sample, you will have different features, data 1, data 2, data 3, through data N. And those data items will then have a tag associated with them, in this case, normal or abnormal. This is assuming that we're talking about a training set, which is a database training set, in contrast to an image-based training set. But when you have an image-based training set, you would have similarly samples of images with tags associated with those images. That training set is used by the machine learning algorithm and can be updated in order to give you some very sophisticated and unsuspected outputs. When you talk about machine learning algorithms and the black boxes, they're often surrounded by what comes before to generate the query and what comes after as a result of what you do with it. It's going to be important to put the machine learning algorithm in context when we're discussing it today, because by putting that context around it, you'll understand better how you can protect it and what needs to be protected. We have identified some examples of typical applications that are popular today using AI/ML technology. Healthcare and medicine is a very big area. It can be used for diagnosing and stratifying patients and treating diseases based on those diagnoses. You can use it in financial services to identify and predict optimal investments, or maybe identify whether or not there will be fraud likely from a particular candidate or applicant. In marketing, it can be done for identifying and presenting personalized advertisements, which is becoming more and more popular. We may see that in social media. We may see that on your Netflix account or your Hulu account as to what ads get presented to you. And that is becoming a bigger part of it, as well as the emails that get sent to you and the content that may be incorporated into it. We can also see it in the context of recruitment or human resources by having the characteristics of the prior universe of successful and unsuccessful applicants or employees, or when applicants or employees have proved to be successful or failed throughout their job. You might use those data characteristics with the machine learning algorithm to determine and predict whether or not this is a good candidate to hire. You also, we also see it in the product production category, where they could have lots of things inputted and end up with a generated result. The famous Daubus computer was that type of system where they inputted lots of different product designs, and they predicted and came out with what they thought would be a new and better product design. And that was what they sought patent protection for to the United States Patent Office. It also, one of the earliest uses, which I was involved with, was using artificial intelligence in terms of security, such as facial recognition or thumbprints or identity recognition, or detecting security risks. Very common places where you would see people use it. Dan, I don't know if you want to supplement a little bit about your experience at MIT and where you're seeing this technology.
Sure. Thanks, Charlie. We at MIT, being sort of a hotbed for research and innovation in general, we certainly see these categories come up as the big ticket items for machine learning. And again, we should probably preface by saying artificial intelligence itself is not a new concept. It goes back to the mid-50s. But I think what's changed of late, after a few periods, a flurry of interest in different types of artificial intelligence systems, is the explosion of available computing power and a ton of data. And I think the confluence of both of those things of late has really made certain techniques that have been previously the holy grail of artificial intelligence more low-hanging fruit. And machine learning is just one facet of artificial intelligence. There are other techniques. And machine learning is really good at essentially doing classification and categorization. And so all of these sectors that you see on this slide essentially are applications of how to adapt or cleverly use categorization and classification to do things. A quick example, of course, is if we're looking at medicine and artificial intelligence in medicine, we're often asked to look at images and determine whether or not they are cancer or not cancer. Again, that's a classification or a categorization. We were asked to do natural language processing, for example, to do translations of languages in real time. Again, it's about categorization and classification, being able to parse that speech, being able to try and recognize the grammar, and being able to translate on the fly. And I believe product and cybersecurity also fall into these categories. So what we're seeing is that there's no lack of breadth of what disciplines you can apply AI into. What perhaps is the rate limiting step is how clever you can use these algorithms and apply them to new modalities. Back to you, Charlie.
Thank you, Dan. And I do think one of the key points which we'll be hitting home over and over again today is that you need a lot of data for this to be worthwhile. And so in contrast to the past, while data was important before, data becomes hugely valuable and monetizable in the context of machine learning and AI innovations. So now we're going to talk about what the current limits on IP protection for AI and ML innovations are. And one of the problems we have to think about is that besides whatever struggles we've had in the last decade with IP in general, the system itself was built at a time when this was way beyond the contemplation of what patents or copyrights were meant to protect. And the innovations that we see today and that we're working with are just a new and different world from what was originally developed. And we see that the strictures and the laws and the guidance and the case law that has developed have not advanced with the technology that's presented. So, you know, to begin with, I think most people on this call, although there may be a few of you that don't, know what different IP tools there are out there, but I want to focus on the relevant ones. And whenever you see the symbol on the left, in this case, the C with the circle around it, I'm going to be using that common symbol to reflect, in this case, copyrights, whenever I'm talking about copyrights. And copyrights are meant to protect, I'm sorry? Okay.
Charlie, we do have a CLE code we want to announce.
Oh, I'm sorry. Yes, go ahead. You can announce the CLE.
So the first CLE code is WC001. W is in whiskey, C is in Charlie, 001. Again, it's WC001. Back to you, Charlie.
Okay, thank you, Sean. Sorry about that. Please make sure you write that down. If you don't put the 4 codes that Sean announces, you will not get CLE credit. So going back to our relevant IP protection slide, we're going to start off by talking about copyright law. And copyright law is meant to protect original expressions, but not underlying ideas. And copyright law can potentially protect computer programs, some data compilations, images, stories, and narratives. And obviously the data compilations is what's relevant for training sets, and computer programs is what's relevant for the algorithms. The next category of IP protection we're going to discuss are patents. And here we have the current version of the patent cover that came out with the 10 millionth patent last year. And patents protect new, not obvious, and useful inventions, but of course they can't be abstract. And computer systems and methods, users interface, and the equipment that runs it are the types of interfaces which are the types of inventions that can be protected by patents, as examples. Contracts, which is symbolized by this nice pink box with the writing and the signatures at the bottom, is what I call a gap filler. And it protects what the parties agree to protect. And we often see it in the context of a data license or a software license or a research and development agreement or an NDA, a non-disclosure agreement. And these type of things are important places for when contract and patent law do not provide you opportunities. When copyright and patent law do not provide you the opportunities of protection, contract law can fill in that gap. And then, of course, there's my favorite, represented by the emoji of a trade secret. And as they say, shh, don't speak, because when you say it, you give it away. Trade secrets protect secrets that have value because they are secret. They must be maintained in secret. There are things such as data or processes or algorithms or compilations or know-hows. Those are things that can potentially be protected by trade secrets, but unless they're maintained in secret, they're not going to be protected. There are other forms of IP protection out there, but these are the 4 ones that are most relevant for today's discussion and what we will focus on. Separately, I want to talk about what are the different components of machine learning systems that you potentially want to protect, my potential innovation spots. And I begin with the data sets, the training sets. The training sets of the data include data items, labels, and the ways that they get generated. This is a very important area where you have people with large collections of data that potentially can be used in a machine learning algorithm for some useful result. In the examples we gave earlier, I think a great example is if you think about all the data that a hospital may have from diagnosing and treating their patients with the labels that the doctors place on that data, indicating that the patient was sick or not sick or cured or not cured. From that information, that is a very valuable training set. It may be used alone or in combination with other people's training sets, and how you collect the data, how you generate the data, how you massage the data, and the resulting training set that comes out of that data are all potential valuable areas where you want to think about protecting and monetizing. Next comes the machine learning algorithm themselves. Sometimes when you think about what kind of machine learning algorithm are you doing? Are you doing a straight neural network? Are you doing a deep learning neural network? Are you doing a convolutional neural network? There's a large selection out there of types of machine learning algorithms that you can use. What matters is what comes in, what it is, what data set it uses, and what the output is. And those are the elements that sort of define what the machine learning algorithm is and how it is defined so people understand what you're using. Sometimes the machine learning algorithm themselves are the invention and something that's really cool and unique and special. Sometimes the machine learning algorithm is sort of like a word processor. We just take one off the shelf, and what's unique and special is the training data set. You have to analyze each circumstance as to where the value lies and what is special in order to understand where you need to protect and value things. There also is the query, the format of what it is that I want to ask the computer to do. Oftentimes, how you get to what the query is and what you present as the query can be innovative. Sometimes it's just not. You also have what comes out of the machine learning algorithm, the output, and what you do with the output. And the output may be something you want to protect. And when I refer to Daubus, which is the example of a machine that was presented as an inventor to the patent office, but the patent office rejected it, they were trying to protect the output of the machine. Finally, you want to think about the context of the machine learning algorithm with its input and output in the context of a larger system. And it may be the whole system or it may be a portion of the system, I illustrate it as a generating an input being fed into the black box, which spits out an output and does something with it. And that is a big part of what we need to think about, is how do we use the machine learning algorithm in the context of the overall protection. So what we're going to do is we're going to talk about how copyright maps into each of these different types of potential innovations, how patents match into each of these type of potential innovations, how contracts map into them, and how trade secrets map into them. And we're going to do it on a innovation by innovation subject. And we're going to begin with the training set. And with respect to the training set, we're going to talk about how can you, as someone who has generated the data and as well as the tags that are used as the training set, potentially protect that training set. Copyright law has a lot of challenges because data sets without enough originality in the selection, inclusion, and/or presentation of data that's included in the database may not be protected by copyright law. And so it can be challenging depending upon what your data set is as to whether or not you can get copyright law protection. Patent law does not protect data as data per se under the so-called printed matter doctrine. And so protecting, you can't protect Madonna song, you can only protect the fact that a CD can hold the song, not that it's holding Madonna song under the printed matter doctrine. Contract law is one of the best options for protecting the training sets, but again, it only covers what the other side will agree to. And for the licensor, you have to make sure you have something sufficient to license. And then trade secret law can be a very good way of protecting a training set, except when you have to deliver the training set to a third party without adequate restrictions, trade secret law may not be available. What a lot of people do is they use other challenges that exist with respect to training sets is making sure that you own the underlying data that makes up the training data. You need to have consent from the data sources, and you could also have regulatory issues, HIPAA or personal information or privacy, etc. If you think about it as a hospital that wants to monetize its training set, its patient's data, it needs to make sure that it gets release of those data from the patients, and it has to comply with the HIPAA laws, and they have to do things to the data to make it so that way they can use it. One of the best things that people do is they use technological solutions as exemplified by this CAPTCHA concept to block people from being able to access the data. And it may be that you don't use any of the traditional forms of IP, but instead you use technology. Now we're going to talk about the machine learning algorithm itself and how it fits into these pillars of IP protection. Under copyright law, they can potentially protect software, but many times people are using open source software when they're doing machine learning algorithms. So when you're using the open source software as part of your machine learning algorithms, you have to be careful of the traps that come with open source software. Patent law may protect a novel and non-obvious algorithm, but navigating Alice challenges, if the algorithm may be considered an abstract idea, can be difficult if you're trying to protect the machine learning algorithm by itself. Contract law is again one of the best options, but like before, it requires the other side to agree, and you have to make sure you have something which is actually protectable. And then trade secret law is a good option if the algorithm itself is kept secret. If it is open source or required to be disclosed, for example, for regulatory reasons, this option may not be available. Next, we're talking about the query. In the context of the query, we don't even talk about copyright and patent law because the query by itself is not really going to be protectable in that area. So instead, we start off with contract law, which to the extent that you have a unique query that's being formulated to be presented, that may be one of the only ways that you can protect it, other than to keep it secret, which again is going to be very difficult. As a practical matter, the protection of a query is going to be very, very difficult without trying to protect it in the broader context of perhaps how the query is formulated or generated. Now we're going to talk about the output. Challenges of who is the author and who is the inventor have made copyright law and patent law probably not available, at least in the short term, for the output, the pure output of a machine learning algorithm. To the extent that it is the machine that is the author or the machine that is the inventor, and it is not because of human creativity that the output results, right now the law does not seem to protect them. And one of the challenges which we're going to talk about is how do we navigate that when we want to try and protect what we're doing with our machine learning algorithms. Contract law, again, is still one of the best options, subject to the same caveats as before. The other side has to agree, and you have to have something to license. And trade secret law may or may not be available depending upon where the output, whether the output is kept secret. And most use cases involve selling the output, so trade secret law, at least for the output, will be unlikely a useful option. So as a practical matter, protecting merely the output of an AI ML program without more will most likely prove to be difficult. Finally, I want to focus on a larger system where the machine learning algorithm with its training set and its input and its output are part of a larger system that puts together a way of generating that input and a way of generating that output. And based upon that, it is, I think, a place where you have the best protection potentially. Copyright law certainly can be very good for protecting software, but again, you have to beware of open source issues. Patent law also may potentially protect a novel and non-obvious computer implemented system and method, but you have to navigate Alice challenges since the algorithms used in it may be considered an abstract idea. You also have contract law subject to the same caveat as before, but when you have a compilation of other systems coming up, you need to make sure that the compilation has all the right holders participating in whatever you're doing with the contract. And trade secret law is, again, potentially available to the extent there are components that are secret. A common strategy is to use trade secret law to protect some components and maybe open source or other things that for other components. But again, you have to consider it in the context of whether you use open source and how restricted by that, or whether for regulatory reasons, you may not be able to keep things secret. At this point, Sean, I think you're ready to give us another CLE code.
Yes, the next CLE code is WC025. W as in whiskey, C as in Charlie, 025. Again, that's WC025. Back to you, Charlie.
Thank you, Sean. Now we're going to talk about, now that we understand generally what AI ML components there are and what the current limits of IP protection are on them, we're going to talk about strategies of how to protect these components and innovations. So again, we're going to go through and try and identify with what are the human conceived elements that we could protect. Are there human conceived elements in the training set? Are there human conceived elements in the machine learning algorithm? Are there human conceived elements in what how the query is formulated and generated and presented to the system? Are there human conceived elements in how the output results and is processed by the system? And then, of course, is there human conceived elements on how these pieces are fit together into a whole? So starting with the training set, which is often where many players in the industry start because they have large volumes of data which they'd like to monetize. We begin with copyright law. One of the things that will protect your training set best is if you alter the structure or content of the training set to incorporate greater creativities. Tags can be an example of a potentially sufficient enhancement because that is the human creative element that determines whether or not this data compilation is tagged as to whatever else it is tagged. In the terms of the patent system, you could consider methods and systems used to generate and update training sets and how you formulate these training sets through various combinations and manipulations of the data. From a trade secret perspective, you have to think about whether it is possible to limit access to the training set. To the extent that you can keep it under lock and key, then you might have the ability to use trade secret law. And the system that most people use is contracts to fill the gaps and try and protect the training set. Of course, technology remains one of the major systems used to block people from unauthorized access or copying where possible. Of course, beware of open source and third-party rights issues. If the training set includes data from publicly available resources or from third parties, and making sure that you comply with regulatory requirements. The next category of things that may be protectable is the machine learning algorithm itself. Of course, because the algorithm is software, software may be potentially protected under copyright law as it's encoded. But again, it only protects the original expression and not the overall function. Patents may be available, but it may be difficult to do just the machine learning algorithm by itself, and instead must put it as part of a larger package. For the patent lawyers out there, think of the Deere case, where the algorithm was an abstract idea, but the fact that the algorithm was used in curing rubber made it patent eligible. You also can potentially protect the algorithm by trade secret law and limit access to the code for the AI algorithm where possible. That may have issues if regulators or customers need to know how you're figuring this out. And of course, contract law remains a very valuable option to protect the machine learning algorithm by itself. As with the training set, you have to be aware of open source and third-party rights issues if the third-party algorithm is used in whole or part. So now we want to talk about protecting the system as a whole or part of a larger system, and to make sure that we include the human input in this. The software protection is available for the system's programming and its components. Patent protection is potentially available for implementing the larger application and may get you around issues of being just an algorithm. Trade secret protection may potentially be possible and may not, depending upon what needs to be made publicly available. And contract law, of course, remains one of the most valuable options out there. And of course, as with all software, you have to be aware of open source and third-party rights. If a third party uses an algorithm that is used in whole or part. Dan, before I go on to the next part, is there anything you want to mention on that part?
I'm okay, thanks.
Okay. So now we want to talk about when you're applying for copyright applications. And in the context of applying for copyright applications, it's important that you make sure that you're not claiming the computer is the inventor, but look for what is the creative input or intervention that came from a human author. While you can name an organization based upon its employees as an author, you can't name it based upon the computer itself being the author. It's important to try and frame the application to say the applicant is the author and the machine is just an intermediary. For example, if applicant X's creative input throws AI into motion to create a specific output, even if the AI is very smart, show what the input is and what it creates as the output. Without showing input or intervention from a human author, the application is likely to fail. We are all cognizant of the poor Narito, who thought that whose photographer thought that when Narito took pictures that he could own it, and we were told that Narito couldn't even own it because he was a monkey and he wasn't a human. And copyright law only applied to humans as authors. When talking about patent law, we have four basic pillars of challenges that we need to overcome and address in terms of any software invention, particularly in the context of machine learning. The first is making sure that we properly define the inventor to be a human. The second is addressing patent eligibility. The third is addressing divide infringement. And finally, it's making sure you have sufficient claim support. With respect to defining the inventor, one of the test cases involved the Davis computer, where the applicants said that the inventor was a computer, and the computer was the one who developed and gave the output which they were trying to protect. The Patent Office issued a denial of a petition for reconsideration of inventorship and said that, sorry, we don't think that a computer can be an inventor. It has to be a human, and therefore the applicant needed to be a human, and since Davis was not a human, the forms were not properly filled out and patent protection was not available. Patent eligibility, as with most software inventions, is always something you have to be aware of. You have to make sure you draft the claims in a way to cover a practical application of an abstract idea instead of the abstract idea itself. It is best practices to make sure that you identify a technological problem faced and the technological solution implemented in the disclosure. It is important these days as a best practice to include sufficient details of how an end result is achieved rather than merely that an end result is achieved, and to have the claim do more than merely state an algorithm, but end up doing something with the results of the algorithm and perhaps treat the patient or something like that. Divided infringement is important. Sometimes these systems involve multiple actors. You always want to claim the claim from the perspective of a single actor. And if you need for the novelty or non-obviousness, the elements that are performed by the other actors, you have to passively claim them in your claims. Finally, we think best practices on claiming machine algorithms includes identifying the data elements and tags in the training sets, identifying the query elements that come in, the form of the output, the type of the machine learning algorithm to be applied, and ideally in the disclosure, we try to include examples and pseudocode of any determining or calculating steps and narratives where possible to avoid potential Section 112 or claim definite issues. At this point, I think, Sean, you're going to give us another code.
Yes, the third code is WC075. W is in whiskey, C is in Charlie, 075. Again, that's WC075. Back to you, Charlie.
Thank you. And at this point, I'm going to turn over to my distinguished co-presenter, Dan Dardani from MIT, and he's going to talk to us about monetization.
Thanks, Charlie. First thing I want to say, well, thank you for providing a thorough overview of the nuts and bolts of machine learning intellectual property strategies. What I'm going to do with the next few slides is talk about how it overlaps and intersects with some real world type scenarios. And everyone's always concerned about the term monetization. And I guess the first thing I want to make it clear is when I talk about monetization, I'm not just going to be talking about dollars and revenue, but I'm also going to talk about the myriad ways that monetization is achieved, particularly within a university context. So next, Charlie. So for me, I'm going to look at monetization as an overall impact that artificial intelligence and machine learning is having, both within sort of the university space as well as outside in the commercial sector. And that's going to include things like the investments that are being made in artificial intelligence and machine learning. And what I mean by investments, I mean both research investments, I mean educational investments, as well as traditional investments like acquisitions and patenting and things of that sort. Next. So we're also looking at scholarly publications, and we're going to also take a look at some licensing trends that I'm seeing from my vantage point. And the goal for looking at all of these questions is going to be to try and really distinguish the hype that we hear about intellectual property and artificial intelligence and the truth. So what's this distinction between sort of the hype and its buzz and what we're really seeing in reality? So again, here's a quote that says AI is the new electricity, and we're going to hardly imagine an industry which isn't going to be transformed by AI. That's Andrew Ng, who's a CEO at Deep Learning AI and sort of a thought leader in space. We also have a quote from the venerable Bill Gates, who writes, a breakthrough in machine learning would be worth 10 Microsofts. And so here we are. But Bill Gates also said that we should all be worried about the threat posed by artificial intelligence. Okay, so PwC says that machine learning and things of that sort are going to increase labor productivity by about $16 trillion globally by 2030. That's an enormous amount. And in the US, a GDP boost of almost 15% from artificial intelligence. And if you prefer McKinsey, their numbers are 13 trillion globally by 2030 and about 16% jump in GDP. So if we want to look at what that means, even if we take a conservative approach, it means that artificial intelligence and machine learning is slated to have about a 1.2% of additional GDP growth per year. And just to put that in perspective, I've given you a few other historical GDP growths from other industries. So the steam engine in the 1800s, it's estimated, was able to increase productivity in the labor force and essentially all economic measures by 0.3% a year. 0.4% a year was for robotics in the 90s, and the growth of internet and IT was 0.6% a year in the 2000s. So we could see that even if machine learning is as important as the experts are saying, we're looking at very good adoption across the industries. And this next slide, which shows you the number of patent applications by essentially AI patent families, I think shows good evidence as to why companies are leveraging and trying to get in on this explosion. So this graph shows essentially, again, the number of companies that are investing in AI patent families. And it shows that the big folks at the top are people like IBM, Microsoft, Toshiba, Samsung, and NEC, Fujitsu and Hitachi. These are folks that understand that AI is likely going to transform the working world, and they are essentially positioning themselves early on as adopters, and not just adopters in the technology, but also owners of some of the means by which these technologies will be disseminated to others. Next slide, please. So investments also are in the educational and research space. So very concretely, at MIT where I sit, I was part of an effort to help create an MIT IBM Watson AI lab. And this was a brand new research lab that was going to be funded to the tune of $240 million over 10 years. So a very sizable investment to create essentially mirrored labs, both within MIT and within IBM and their local presence in Cambridge, Massachusetts, to have this cross-pollination along 4 pillars of machine learning. Another investment even bigger at MIT has been the $1 billion backed new Schwartzman College of Computing. And this is a brand new academic school at MIT, the first time in over 60 years that MIT has expanded essentially and included a new college, or a new school as they call it. And this means 50 new faculty positions. These faculty are going to be cross-disciplinary. They're going to be essentially research clusters for doing interdepartmental studies and inquiries into how artificial intelligence and machine learning interacts with many disciplines. Obviously, computing being right at the forefront, things like machine learning and natural language processing, but also even in the social sciences and in the ethics and societal implications of AI. For example, AI techniques being applied to criminal justice and making sure we understand the data biases that inform some of these techniques. So this is a large investment across the board that's really meant to bring not just the MIT community, but you can argue the entire sort of, citizenry more bilingual with things like artificial intelligence and computing. Now, the US government is also a major player in these investments. And if you do some research, you'll see that they are investing heavily in the standardization of AI, the standardization of data, the access to this standardization of data, because they understand that really in order for this all to work, there really needs to be, huge troves of data that for the most part have been standardized so that we can develop accurate benchmarking and test beds in our techniques, in our hardware, and in our algorithms. And at MIT, they are partnering currently with the Air Force to create an artificial intelligence accelerator for ventures and businesses. And that's $75 million over 5 years pledged. And MIT is not the only place where this is happening. It's just, you find similar investments at Carnegie Mellon and University of Pennsylvania, and at Stanford and other universities and labs and centers around the world. Next slide. So this slide shows some of the output in terms of academic publications in the AI space. And this is also a type of monetization or a type of impact, because again, how you get this information out and how you sort of are cited in this space is a type of currency. And you'll see these are some clear countries that are this effort, China being among them, the United States, of course, also a major player. And this some schools that have, I'd say, been proficient in producing scholarly output in this space. Next slide.
And in this slide, I mean, what we're seeing is the Americans seem to be way behind the Chinese in this space. Is that what this is intending to reflect? Or are they just more publishing than we are?
Well, I think what you'll find is the universities in China, as well as the sort of have definitely made it a goal to try and up, if not overtake, in terms of output. They understand that the AI and the machine learning potential for their economy. And the or 26% bump in their local GDP is what the PwC report showed just for China alone. And so they are making tremendous strides to try and overtake in terms of output in publications as well as patenting. And I guess the question then becomes, is that the right sort of place to focus your resources on if you're trying to become a major player?
And Dan,
I think that's a question for another webinar.
But Dan, just in terms of the IP protection, is it because there's just more work being done in China, or are we just keeping it more secret in the United States? Is it that we're relying more on trade secret law than patent law? Or is it that we're publishing it anyhow and they're just publishing more?
It's a good question, Charlie, and I'm not sure I have the data to speculate on it. I think each of those could be a component.
Okay. If they could advance to the next slide for Dan.
So this correspondingly shows patent applications by many of the top universities. And I think your point, Charlie, also carries over to this slide as well, because you'll see most of the major players in terms of patenting are in China and other parts of the world.
At least in volume, if not in substance.
But I think what I'm going to say in a minute, I think is going to perhaps give some justification for why places like MIT and others aren't so quick to be jumping into the patent everything arena.
Okay, next slide.
Next slide. So here we see a trend, obviously, the number of times deep learning was mentioned in a specific AI patent when it was mentioned in the year it was published, so number of publications. And what we can see is tremendous growth in deep learning. Deep learning is just essentially a machine learning technique that is based on a neural network. And when your neural network has internal layers of 2 or more, you are now in a deep learning environment. So it's a type of a substantial or significant layering of a machine learning that allows you to do a particularly good job of examining many different features, as opposed to just perhaps looking at 1 or 2 layers and doing a quick read of the data. Next slide. Okay, so now let's look at some of the trends that we're seeing in the commercial space. I'd say the scene was initially a little bit like the gold rush, and there was a flurry of activity to try and stake a lot of claims in the ground on various machine learning algorithms. And the impression at the time originally was that these algorithms were going to be like the ores of the original gold rush, the thing, the asset, the thing that was going to give us a proprietary advantage, and licensees would be lining up at our doorstep in order to take the licenses to these algorithms. And what we found after doing that for a number of years was there really wasn't much of a line outside of our door. And I guess the question was why? And I think what we learned was that there are a number of reasons why the algorithms, although perhaps important in certain contexts, in certain cases, increasingly were being shared openly. They were seen as a kind of open resource, a commodity. And the other fact was a lot of these algorithms were being tweaked in the very process by which the data is crunched in order to make them more precise. So there's, the runtime algorithm, and then there's the training side algorithm, which in some respects informs the coefficients and builds the precision by which you're hopefully able to get high resolution on your labels and your output. And it's that sort of black box tweaking, that black box training that tweaks your algorithm to make it better in a way that you may not have anticipated when you originally set up your claim. And so we found that the algorithms, by their very nature, were being tweaked and evolved in order to keep up with the immense amount of data that was feeding them and making them more precise. And so it led to a situation where you might spend a lot of resource protecting an algorithm, only to find that that algorithm had a certain half-life and was now a little bit archaic just a few months later, because now the algorithm had shifted and moved. And so the value of protecting the algorithm started to weaken, and it seemed more and more the value was being attributed to the training sets and the data, essentially the way that the coefficients are weighted, the arithmetic that makes that overall training and sort of iteration really what is the lifeblood of a machine learning technique, and what makes it so interesting over conventional programming was more and more being relied on as the asset, the ore that we needed to protect. Next slide. Of course, as Charlie said before, this creates its own set of unique issues. In a university context, the first issue among them is, do we own the data? Now, there's lots of data sets, some of them publicly available, some of them not, but understanding what data you're using and how you're labeling your data and where your data is coming from is something that is not always, let's just say, the provenance of it is not as good as we'd like. It's not like blockchain where everything is logged and available for scrutiny no matter how you look at it. Another issue with the data was, of course, whether or not it was subject to GDPR and other types of electronic health record protections, and whether or not you had permissions and releases if we were looking at patient data to allow these types of data sets to be commercialized.
And just in that context, it's not only do you have the rights to do it, but are there regulatory constraints that are placed on you and what you have to do in order to commercialize them? That goes hand in hand with that.
And it gets even more interesting because we have to even start asking questions like, what exactly is meant by data? Because there's many different layers of data, like an onion. And we can look at things like raw data, like, for example, the numbers in Charlie's table earlier on that were essentially part of the feature sets that were being measured, hopefully to maybe determine whether or not the image was normal or abnormal. But there's that raw data. There's also the metadata that informs what we do with that raw data, the transformations of that raw data. And then there's also visualizations and other knowledge and inferences that you can conclude when the algorithm runs on that data. And that is another type of research result or data. And these are the things that often get turned into charts and graphs that show up in publications. And so the question then becomes, what exactly do we mean by data, and what data do we feel we have rights to commercialize or to sell? So what is best for the data becomes an interesting question in this context, because you might argue that the data could be best served by making it openly and publicly available for other researchers to use, or you might think it's better to put it behind a proprietary paywall, and maybe make it available under a data use agreement, or some standardized or bespoke type of contract. So these are such challenges that universities are seeing with their data. Next slide. So again, the other thing we have to look at when we're thinking about this is if these models and if these algorithms are increasingly being shared openly, well, what about the software implementing that model, the copyright in the program, as Charlie said before? And of course, there might be enough value in protecting some of the applications that are implementing these algorithms, even if the algorithms themselves are openly shared. But the question is whether or not is there enough value in that research code to sort of warrant commercial license. I think that's a question that universities are struggling with when they think about how to monetize or how to really think through their portfolios when it comes to artificial intelligence and machine learning. There's a tension there because a lot of the inventors and a lot of the folks in this space have a tendency, almost a proclivity, for wanting to openly share these things in the open market. The example I'm thinking of is Scikit, which is sort of an open, scikit-learn is a sort of open machine learning repository for Python. It's essentially a way, mostly everyone that's doing anything in machine learning knows about scikit-learn and uses their very open algorithms and then just takes them in a proprietary way when they think that they have something that might be of value there. So that's another business model, is whether or not you want to work with sort of an open source where you are not so much worried about protecting the product, you're not so much protecting a platform in artificial intelligence, but you're really protecting a particular data set that you perhaps have a stranglehold over that's not available to Google, that's not available to Amazon, that's not available to Facebook, and therefore gives you some competitive advantage. And we are experimenting with different types of licensing templates to, let's just say, entice folks that would otherwise want to release these things openly into open source and not work within the university licensing to get them to work with us. And we're exploring very standardized, sort of fast track licensing. Some of them could be equity only, for example, so you don't get into messy arguments and negotiating of royalties and speculating what those royalties might be. So these are some of the toolkits that we're now just sort of using in the university to get to that space.
And Dan, are those the fast track licenses too? If you automatically go through it, you can get the license?
Yeah, exactly. And generally these are software specific, no patents, but we want to provide a quick and easy path for a researcher rather than having to go an open source route and then work from a public fountain, to take a quick and easy sort of fast track license out of the university, which has these ancillary benefits of being associated with the university as opposed to being sort of outside the moat. Next slide. So I think what we're seeing here is there are some pitfalls for universities when it comes to patenting algorithms. There still is plenty of space for protecting hardware. There still is plenty of space for protecting things that improve how AI and machine learning will work, right? So if you can create software or hardware improvements that make a CPU better and stronger, right? So then maybe I don't have to invest in GPUs as much. Those are still strong patents. And those are the patents that we still want to file on. But whether or not we want to file on a machine learning technique to do X or a machine learning technique to do Y, it's going to require a lot more consideration, in part because of the judicial exceptions that Charlie talked about with Alice and abstract ideas, but also Mayo Prometheus, which talked about conventional and routine steps and not using things like applying something as a soundbite, just like we couldn't just say and apply it on a computer doesn't really make something that was otherwise not patentable patentable. We have to also be cognizant that just saying doing field X but doing it with machine learning doesn't somehow magically render that application patentable. So what we look for when we are looking at the patenting at the universities, we're really looking for the overall story. Does this tell a compelling story, and is there a system behind it that governs that story? It's not so much whether or not this new classification algorithm improves the speed or the resolution of looking at certain images by 2%, and therefore can tell if it's attached to the top of a driverless vehicle, what is a pedestrian and what isn't. But the story might be, as a system coupled with a few other techniques, we now have a driverless car that prevents, fatal accidents and crosswalks. And that's a much more compelling story. And that system seems like a much better patent to file than just trying to explain a mathematical model at 2% yield. And so that's the type of metric that we use. And that's why MIT's name was not at the top of that list when it came to patenting. We have a more reserved approach. And I think what we take is a little bit more of a higher bar for investing in these. And I'm not sure that that same bar exists across the board at other institutions. And I think that also is one of the reasons why some of those other universities perhaps outpace the US in that regard. So again, we try and scrutinize whether these techniques will still be relevant by the time the patent may issue. We look at whether the algorithm, by its very nature of iterating back and forth with its data and changing its variables, will essentially change the claim in a less than trivial way, which could weaken our patent and weaken our ability to litigate that patent if it's successful. And we also understand that in this space, we're dealing with a lot of fast-paced innovation. And, startups are happening very quickly, and they're growing, and they're getting acquired. And, we want to make sure that we are there to at least facilitate that, but not file patents that are going to be these big sort of aging dinosaurs that could actually wind up hurting innovation and hurting the speed by which some of these techniques get adopted and disseminated. So,
And I think we're coming to the end of our time.
well, that's good, because that was my last point.
Great. If we go on the next slide for a second, I think, Sean, you need to address the last CLE code.
Yes, the last CLE code is WC050. W's in whiskey, C's in Charlie, 050. Again, the last code is WC050. As a reminder, please complete that eval by the end of the day tomorrow, Friday, June 19th.
If you go to the last slide for a second. Unfortunately, we have run out of time, so we're not going to be able to address the questions online. But if you email me at cmacedo@arelog.com, I'd be happy to address your questions and or have a conversation with you about the subject matter of today's presentation. I would like to thank World Congress for hosting this. I'd like to thank my firm for sponsoring it, Amster, Rothstein, Ebenstein. And I want to thank Dan Dardani in particular for his wonderful and excellent presentation and the preparation of this presentation. We hope that you will join us again at future webinars and conferences. Please follow Amster, Rothstein, Ebenstein on linkedin.com to learn about other upcoming presentations. And thank you once again.
Great. Thank you, Charlie. Thank you, Dan. Just a quick wrap up. Again, thank you to both of you. Thank you to Amster, Rothstein, and Ebenstein for making today's session possible. A reminder to folks, the webinar has been recorded. You'll receive a link to the video. And for those of you applying for CLE credits, a reminder to submit your form by the end of the day tomorrow, Friday, June 19th, and you will also get a copy of the PDF if you need it. This concludes our webinar today. Thank you so much for your time. Have a great day.